Hello, everyone, and welcome to the Employment Law Counselor Podcast presented by White & Williams, LLP. I'm your host, Jeff Stewart, and welcome to the debut episode. We're glad you found us. Our goal here at the Employment Law Counselor Podcast is to give you insight into the practical applications of the world of employment law from the view of two seasoned attorneys. Each episode, we will focus on one specific employment law, how it came to become a law, what parts of the law are relevant in today's workplace, and some tips to ensure that you and your company stay in compliance with the law. While our podcast is not legal advice, it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, please give us a 5-star review and subscribe so you never miss an episode. Today, we'll be covering the accommodation requirements of the Americans with Disabilities Act, better known as the ADA. I'm thrilled to be joined by George Morrison, who practices with me out of our Lehigh Valley, Pennsylvania office. How are you doing today, George?
I'm excellent. Great to be here, Jeff.
Oh, and thank you for jumping into the world of podcasting with me. I'm sure it'll be quite a journey.
Looking forward to it.
All right. Well, let's just jump right in. We're talking today about the ADA. Now, the ADA is a rather broad law. George, can you talk a little bit about some of the history of the ADA?
Sure. The ADA has been around, Americans with Disabilities Act has been around since about 1991. So it's been around a good amount of time. It's still considered, I think, a young law in the legal realm. But there's many different aspects of this law. And just so we're all aware, in the real world examples. So when you go to a restaurant, public accommodation, and you see ramps, for example, to access a building, that would involve a title of the ADA. If you go rent an apartment, for example, with respect to housing, that would involve another part of the ADA, another title, as we refer to them. And then, of course, we have issues with respect to employment law, which will be our primary focus today. And the ADA basically sets forth a whole lot of duties, responsibilities, and obligations on employers with respect to employees that have a disability.
And this is an area that I know in my 20 plus years of practicing, and I know, George, in your years of practicing as well, we have seen become more and more prominent and a bigger area of employment law as, frankly, the law has expanded to include more and more people as being considered disabled. So today we're going to focus on not disability discrimination necessarily, which is a whole separate episode, but specifically an employer's duty to accommodate an employee with a disability. So, George, can you give our listeners the general rule for accommodations?
Sure. And before I do, Jeff, you already indicated, in my view, under the ADA, when it comes to employment-related issues, there are three primary silos that I think of. One is the discrimination claim, as you referenced, where an employer or manager may be making, for example, disparate remarks towards someone expressed based on their disability. Another silo is this concept of accommodation that I'll talk about in a moment. And then the third are retaliation claims, which we may touch upon throughout this episode. So with respect to accommodations, these legal requirements trigger when an employee comes to his or her employer and indicates that I'm not able to perform some part of their job because of some physical or mental limitation. And when the employer becomes aware of this situation, under the ADA, certain legal obligations trigger, including providing an accommodation and engaging in an interactive process to determine whether this person can be accommodated so that they can continue to perform their essential job functions.
Now, George, you used a legal buzzword there of interactive process. And for our listeners, the interactive process essentially requires an employer to talk with an employee about what their limitations are and how the employer may deal with those limitations to allow the employee to do their job best. Would you agree with that plain language statement?
Absolutely. And the focus there will be on doing something to allow that employee to continue to perform the essential functions of their job.
What is an essential function?
An essential function at its most basic core are the most basic job duties and responsibilities of a particular position. I like to give the example of someone's working in a hospital and their job is to move operating room trays around. And those trays typically almost always weigh above 20 pounds. An essential job function of that role is probably going to be able to lift over 20 pounds. So that would be an example of an essential job function for that role.
And similarly, if we have a receptionist, the ability to speak on the phone would be an essential job function for that position.
Absolutely. And in the world we live in today, for example, with telework, perhaps an essential job function of that receptionist will be to have to report to work and not telework. So essential job functions vary from position to position, and it's really got to be evaluated on a case-by-case basis.
Now, I know I get a lot of questions from employers, and I'm sure you do as well, where employers are hesitant to ask questions of an employee who may have a disability, and to really raise this because we've been taught we don't talk about things like this. What are you allowed to ask as an employer about an employee's disability?
Sure. And under the ADA, I mean, recognizing that employers do have all these obligations to potentially accommodate someone, the law recognizes that there has to be some form of communication, and employers are allowed to delve in with limits into certain areas with respect to the employee's situation. Those limits are you can ask and seek information about, is the person actually disabled? That's fair game. And, with respect to the accommodation process itself, it's completely permissible for an employer to ask questions surrounding the type of limitations that disability causes. And in turn, it's fair to seek guidance from, for example, an employee's primary care physician about the types of accommodations that would be appropriate that would allow that individual to continue to perform their essential job functions. So you're definitely allowed to ask questions. But again, I think the theme and the takeaway is you want to make sure that your inquiries are focused on, one, confirming the disability, the nature of the limitations as second, and third, what of any accommodations could possibly be provided.
And I think it's important to note that an employee does not have to use the word, I need an accommodation. They don't have to specifically ask. If an employer sees that there is an issue, the employer has a responsibility to say, hey, I'm noticing that you're having trouble with this aspect of your job. What's the reason for that? And if word of a disability or suspicion of a disability comes out, it's up to the employer to ask and then to engage in that interactive process that we mentioned earlier. And George, can you kind of walk us through, what the employer's responsibility is in that interactive process?
Yeah. And, just to dovetail off what you just said, Jeff, I think the phrase that we like to use is there's no magic words. No magic words will trigger this obligation on an employer to engage in this interactive process. And when we say interactive process, we're really just boiling it down to a dialogue and communication with the employee. So as part of this process, for example, the employer may reach out and ask for, additional medical information from the employee's primary care physician. Once that information is received, there probably most likely will be a follow-up meeting with the employee to better understand what accommodations are being sought, whether there's any alternative accommodations that could be provided. And that's really what it's all about. And most importantly, in the employment world, documenting the file that this dialogue actually happened. Because, as I mentioned, I view as three primary silos, the failure to engage in this interactive process is a technical violation of the law. So even though you may not have a manager, expressly discriminating against someone, you can still be found liable under the ADA for not having this most basic dialogue. And that's why it's so important to document it.
Excellent point. I mean, the biggest thing is not whether you grant the accommodation or not, but it is whether you are actually engaging in that process with the employee. Now, I thought it would be helpful if we ran through a couple of potential hypothetical situations. So let's say an employee comes to you and says they've been diagnosed with a degenerative eye condition, and it's making their eyesight worse and worse. And they've asked for a 48-inch computer monitor so they can see what they're doing better. How would you walk a client through dealing with that kind of a request?
Well, I think I would start off with, in this situation, you have an employee that is coming to you expressly indicating that they may not be able to do their job because of some what is clearly probably going to be a disability. So the number one advice is the employer has to do something. And I think the EEOC guidance is that it should be done, quote, promptly. Bottom line, the obligation to engage in the interactive process has been triggered under this circumstance. And the advice would be to, engage in a dialogue with this employee. And that dialogue could take form of a written or verbal communication. The most likely first step would be sending that employee a medical certification form that he or she could take to their primary care physician or whatever medical provider is assisting that individual, and seek additional information about what the disability is, the limitations, and what reasonably could constitute an accommodation for that person. Once that process is continued, that doesn't end your inquiry, that doesn't conclude your obligations. Rather, you should then have a further dialogue with the employee to better understand, is the monitor the only potential form of accommodation? Is there something else we could do? And then you engage in a determination as to whether the employer can reasonably provide either the requested accommodation or another accommodation without presenting an undue hardship on the organization.
And reasonableness isn't just cost. I mean, a lot of times that's where employers will go, but it is not just cost, because let's say they're asking in this case for a 48-inch computer monitor. If somebody's working in a cubicle, that takes up almost the entire cubicle. It's not practical from that standpoint. And I mean, I'm not sure the TV in my living room is 48 inches. I can't imagine sitting from a monitor that size and working. That might not be the best. And maybe we can do a 32-inch or something to that effect, where it's a larger monitor and still meets the employee's needs.
Absolutely. And I think the fair takeaway there is that you don't have to automatically give what the employee asks. And again, that's why that dialogue can be important. The information from the physician can be important because, Jeff, to your point, maybe we don't need a 40-plus inch. Maybe a 30-inch would be sufficient. And the word we're looking for is, whatever we do, will it be effective? So if that smaller monitor would effectively allow this employee continue to work, to perform those essential job functions, that's going to be an appropriate accommodation, and you're going to have met your legal obligations.
You mentioned essential job functions a second ago, and we talked about them earlier. One of the points that we didn't make that I want to make sure we make here is that really essential functions should be included in a person's job description. That is a place where it can be done before the need for any kind of accommodation is ever made or is ever asked for, so that we know this is what we think are the essential functions of this position, not necessarily this is what Susie does and this is what we're going to say now that she has requested some kind of a leave. So with that, I want to give you another hypothetical, because we've been talking to this point about physical disabilities, but more and more we're seeing mental and emotional issues being considered disabilities. In fact, among EEOC charges filed in 2020 that cited disability discrimination or a failure to accommodate, the two most specific impairments that were listed were depression and anxiety, not physical, but mental and emotional disabilities. So if an employee says they're dealing with anxiety and need to work from home as a result, how would you handle that type of a question as an employer?
I think this is a great hypothetical, because what I find are, unfortunately, I get involved in a number of cases where employers mess up when it is a mental issue as opposed to the physical issue, in particular with anxiety, because it's a very fine line as to when the duty to engage in an interactive process starts with respect to anxiety. Many people have anxiety. When does that cross into the realm of ADA? And my advice essentially would be is to, when you're on notice, you start the interactive process, that dialogue with the employee to better understand. Issue that paperwork if they're seeking an accommodation with respect to anxiety, to get feedback from a medical provider to understand whether that anxiety rises to the level to impact a major life activity, which is a buzz phrase under the ADA, of course. And if the information coming back is the anxiety is severe to where, major life activities are being impacted, we need to continue with the accommodation process and better understand what could potentially be done to accommodate that employee to maybe decrease the level of anxiety that would permit them to continue to perform their essential job functions.
And I think one of the things that is important in this highlights is there are many times an employee will just come to their employer and say, you know what, I am just feeling super stressed by my job right now. And that may trigger at least an inquiry. Does this rise to the level of a disability under the ADA? Because we think of stress as more transitory, it goes up and down. We think of anxiety more as a condition which may get elevated at certain times. But again, the response from the employer needs to be the same, which is we need to ask questions and determine whether or not the ADA is triggered. Because if it is, we have a responsibility to engage in that interactive process. Now, George, what about the work from home as an accommodation? This is something that 10 years ago, I'll say, most employers said, well, we will not do work from home as an accommodation. We don't want to set any kind of a precedent because it opens the door for more people to ask to work from home. And even 5 years ago, we saw that. And then COVID hit and many of us were forced to work from home. What do you see as working from home as an accommodation request? And do you see employers granting that more often than they used to?
To start with, I think employers have become better educated on what can constitute a reasonable accommodation. Many times we only think about moving a desk or physical, but understanding that accommodations can take so many different forms. It can take leaves of absences. It could be modification of where you actually work. So where we're left with telework is, we're coming out of a pandemic. The EEOC did issue some guidance a few months ago indicating that just because you converted your workforce to a remote workforce because of the pandemic, it doesn't necessarily wed you into having to do that indefinitely into the future. But with that said, and Jeff, I think you'll agree with me, if you're presented with a situation that someone is requesting to work remotely due to a disability, and that person has been working remotely for now almost 2 years and has been performing their job duties and functions successfully in that environment, it becomes a very difficult argument to deny such a request at this point in time. Now, again, it's very case specific and it requires a case by case analysis on each particular job, the needs of the company at the particular time. And, the typical lawyer answer is it will greatly depend. But I think sitting here today, it's a difficult argument to make that it is not possible to have someone work remotely.
And I think an important distinction is how long they're requesting to work from home. A permanent assignment is very different than a temporary assignment. And that's one of the things that as an employer, you can ask. And during this interactive process, that's one of the questions to ask is, are we looking at a permanent issue or are we looking at a temporary one to address a particular problem? And the answer may be different as to whether or not you grant something if it is temporary versus permanent. We've been talking about the ADA claims, and I wanted to give some statistics because, well, I love statistics. And when you can find good ones, they're always interesting. So I said earlier that anxiety and depression were the two most cited disabilities in 2020. And in fact, in 2020, more than 1/3 of the EEOC charges had disability claims as part of them. 1/3. The average settlement of an ADA claim through the EEOC was over $22,000. So these are not small claims to settle. These are not $1,500 and go away. And I'm sure we could get some. If we looked at every single one of the cases, there would be some that are in the hundreds of thousands of dollars, if not in the millions of dollars. So that really highlights the need to be on top of the ADA and make sure that we know what we're doing and we are doing everything that is required under the law. So as we wrap up this inaugural episode of the Employment Law Counselor podcast, I want to end every episode with a few takeaways, a few good things that people can walk away from this podcast with and say, you know what, this is something that I need to know. why don't we do 2 or 3 of them? I'll start and then you do one and we'll kind of go back and forth. But I think the first and biggest one is that the interactive process that we talked about does not require any particular result. It simply requires communication. And failing to engage in that process is a violation of the law, even if what the person was requesting was completely unreasonable. That doesn't matter. If we don't have the discussion, we have violated the law. George, you have a good takeaway for people?
Yeah, I think a very important takeaway is everything that we've been reviewing today about this legal obligation to have a dialogue. It's really important to recognize that it's a continuing obligation. So just because if you have an employee, John Smith, and you provide an accommodation at one point in time, situations change and it's an ongoing obligation. So to the extent a disability becomes more severe and a restriction changes, it's really critical that we understand that that legal technical requirement is an ongoing legal obligation. And just because you do it once does not mean you're all set indefinitely.
And I think another one I would have would be there are no magic words. If you see an employee is having an issue or they raise an issue, but they don't use the word accommodation, they don't use the word disability, you're on notice and you have a responsibility under the ADA to engage in that interactive process with the employee to make sure that they are able to continue to do the essential functions of their job. So with that, I want to thank you for joining us on this debut episode of the Employment Law Counselor Podcast, where we try to make sense of the world of labor and employment law. I also want to thank George Morrison, my colleague, for being with me on this first episode. Thank you, George. I appreciate your time.
Pleasure to be here.
If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe and stay compliant.